Many of you might already know that any parent or guardian that fails to ensure that their child attends school regularly, which essentially means whenever they're required to attend school, might be guilty of an offence. And anyone that didn't realise that, this video might come as a bit of a shock to you. So local authorities have various powers to ensure that children attend school regularly. They can even obtain a parenting order, which requires you to go to parenting classes, and you'll also have to do what the court says with regard to improving your child's attendance at school. If the local authority thinks that you need support to get your child to go to school but you're not cooperating, they can also obtain an education supervision order, at which point a supervisor will be appointed to assist in getting your child back into education. The local authority can do this instead of or in addition to prosecuting you. One of the most common reasons for a case to be referred to a local authority for prosecution is parents taking children out of school for holidays. Many of you might think that they will never do this and it's just a few days and it doesn't matter. But even in Staffordshire alone, just this year, there's at least almost a dozen parents that have been prosecuted and fined upwards of many hundreds of pounds plus court fees and victim surcharges because they took children out of school for purposes of going on holiday without the school's permission. It's section 444 of the Education Act 1996 that makes it an offence to fail to secure regular attendance at school of a registered pupil. There are of course various defences, many of them statutory defences set out within section 444, which I'll link in the description below. One of them, it is a defence for a person charged with such an offence to prove that he had a reasonable justification for his failure to cause the child to attend regularly at school. Looking at subsection 2a, it provides that the child shall not be taken to have failed to attend regularly at the school by reason of his absence from the school at any time if the parent proves that at that time the child was prevented from attending by reason of sickness or any unavoidable cause. But case law has held that this must be something to do with the child and not the parent. For example, if the parent has a certain illness or disability, but this does not apply to the child, this is not caught by this unavoidable clause within the Education Act. Whether you are familiar with this law or not, you might not realise the severity of the offence. Even though it's a summary-only offence, it does attract a potential prison sentence. It does attract a fine of up to £2,500, imprisonment up to 3 months, or both. Naturally, it's in the child's best interest to attend school and the school's interest to ensure that they attend school, and many schools are more proactive about this than others, but they can contact the local authority and you can end up being prosecuted for it. More and more parents over recent years have been prosecuted for this offence and fined an average of between £200 and £800 in those cases that I've read about. But just be warned that just like any other offence, if you are prosecuted more than once, it is more likely to be much more severe and could, in the worst cases, attract a prison sentence. So just like many other laws and offences, some of you will agree with this, some of you will not agree with this. I'd be interested to read your views and your comments in the box below, so please leave those there. Please do like this video and share it with anyone that you think might be falling foul of these rules and you want to look out for them. Also, any other suggestions and requests as to areas of law that you want me to look at, and in the meantime, thank you for watching.